Hey everyone, welcome to the legal fundamentals of seizing and searching electronic devices. My name is Colin May and I will be your guide throughout this journey. So some of this may be a basic refresher of legal principles, but we will be generally talking about criminal investigations by government agencies, not private sector actors. That's really beyond the scope of this. It's also important to remember that the law and technology changes. So this will really be a very high level discussion of these principles that apply at the time of this recording. You're encouraged to do further research to ensure the most up-to-date information, as well as obtaining competent legal advice. Remember, the default answer is it depends, so have your facts ready. Think about for a minute all the data that your cell phone has. Probably as text messages, contacts, photos, videos, application, financial information, passwords, and really so much more. From a legal perspective, we need to delineate two things. First, seizing a device, and then secondly, searching it. They're often conflated, but they are two separate things. The Fourth Amendment limits the ability of government agents to search for and seize evidence without a warrant. Here, it's important to remember that government agents cannot effect unreasonable searches and seizures, and warrants have to be issued upon probable cause supported by an oath that particularly describes the place to be searched and the persons or things to be seized. Seizure includes things where there is a possessory interest in that property. The court has characterized electronic or intangible communications as a seizure. It's also important to remember that a search occurs because there is a legal expectation of privacy, and that has to be reasonable. So these are the key points to remember when we talk about a Fourth Amendment search. Reasonable expectation is a two-pronged test. They have to be met in order to say there's a reasonable expectation of privacy. First, there's a personal or subjective expectation. This is by the individual themselves. Secondly, the question is whether society has recognized that reasonable expectation of privacy exists and is objectively reasonable. This plus this equals a reasonable expectation of privacy. The bottom line is if there is a reasonable expectation of privacy, you need to get a warrant. Warrants describe property in a manner that leaves agents or investigators executing them with no discretion as to where to go and what to take. Particularity is sufficient precision to separate the items that are to be seized from the items that are to be left alone. In many cases, you'll actually see property to be searched as a separate attachment that includes clear descriptions and photographs as well. In an affidavit, it's important that a couple key things are included. First, the affiant has to produce a background, including their training, education, and experience in working these types of cases. An overview of the case is particularly important, especially when dealing with complex subject matter or very large cases. Certainly the facts supporting the probable cause are critical. In digital device or examination, the importance of defining and describing terms and explanations for computer need to be included. Finally, as we just noticed, attachment A, the place to be searched, and attachment B, the items to be seized, are critical. So this is a 54-page affidavit that was recently unsealed. If you follow the QR code, it will take you there and you can follow along. It's important from the very beginning to specify which location or locations you are going to try to search. In this case, it's Jefferson City, Tennessee. Then the affiant or the investigator, the police officer who is seeking the search warrant, will describe their background. The importance of describing which crimes and their elements are important. Here we're talking about conspiracy, 18 United States Code Section 371, as well as 1343, which is wire fraud, and 1028A, which is aggravated identity theft. In the probable cause section, we really need to be explaining who we are investigating, what the scheme is, how the subject is related to the location we are searching, and how the subject is related to the items that we are seizing. In this case, we have financial evidence, computer evidence, and emails. Here we also indicate that there is a website that basically allowed individuals to advertise for remote work in the amounts of identities that were other than their own. This is a copy of that website. This is from the Internet Archive's Wayback Machine. And as you can see, it's very interesting because it is a Google Doc. It's not actually a website in HTML or other type of actual web interface. It also, interestingly enough, has a Telegram and a Skype address. These are all important details that can be included. Here we need to discuss the overview of the scheme and the process in how it works. So here we have an individual in the Ukraine, who is operating laptop farms in the United States. Essentially, there would be an individual who would request an account associated with a U.S. person, a U.S. identity, then get employed by a U.S. company who would then enable the U.S. company to hire them and ship them a computer to a U.S. address. Now, the IT worker claims to be located in the United States, but is actually not. This is a photograph of a laptop farm. This is not from the specific case that we're talking about, but again, this is the kind of visual that could be very helpful in describing what kinds of issues are at play. As you can see, there are multiple laptops, multiple power sources, and again, all these are something that can be considered in the affidavit. This photo is from Zillow, and this shows the address 821 West King Street, Jefferson City, Tennessee, otherwise known as Subject Premises 1. Here, it's important to note that the specificity in the affidavit describes a laptop, a shipment, a specifically make, model, type of laptop that they expect to be found there. That is the type of specificity that we're looking for. it's very important to include a discussion of computers. This is because digital evidence is complicated. Not everyone has the same technical knowledge. Digital devices can be both the means to commit the crime as well as the ability for them to store evidence of the crime. Again, this just gives the judge a clear understanding of what is being sought and how they all connect. The independent component doctrine says that computer systems are really a combination of interconnected components, including some by wireless means. So if you say, I just want to seize the PC, the personal computer, it doesn't actually give you the authority to take the entire computer system. So you really need to be specific because they can all work together, and you need to be able to justify in detail why you're taking certain things. This is attachment B, the property to be seized. Again, these need to be described in detail. Can be either categorized as fruits of the crime, so property that's obtained by the criminal activity, or instrumentalities, so how they've been used to commit the criminal offense. These are in a standalone section because this may have to stand on its own, especially if the warrant is sealed. Remember that the Fourth Amendment requires as much specificity as possible in describing what items are to be seized. This also is important to provide search and seizure instructions to the agents who are conducting the actual search. So in this case, it was really a much broader and very complex scheme. A woman was charged, as well as this individual, Alexander Didenko, for operating laptop farms and basically allowing clients to get hired using false identities for this remote work. $6.8 million of revenue allegedly went to the North Koreans and compromised the identities of 60 Americans and affected nearly 300 companies. This is really, really a very wide-ranging scheme. Again, it was a 54-page search warrant. But this is, again, a very complex scheme, lots of things happening, and this is what happened. And of course, the website itself is no longer operable. It's been seized by the FBI, so that's an important piece. And the State Department has provided a reward for information on these individuals who are involved. And as you can see, there's also a Tor link through the dark web so that people can do this anonymously and report information. It's important to remember that we cannot go beyond the edges of the warrant. This is what the scope is. It defines what is important in and what is allowed by the judge. And so there's really no ability to wholesale rummage. And this can be challenging because, unlike paper records, digital ones can be altered or renamed, they can be hidden. So there's a lot more at stake in the scope of the warrant for digital information than in typical paper records. So let's say that you're doing a tax fraud case and suddenly come across information regarding a murder for hire scheme. Stop! You need to get a new warrant. If there's a new crime, that requires a new warrant. Document everything you've done, stop what you're doing, and call your prosecutor. Here, let's talk about the Federal Rules of Criminal Procedure. This is critically important because it means that electronic evidence should be handled in the exact same way as any other evidence. The chain of custody and integrity of the evidence must be held intact, because that ultimately is what will enable the government at trial to authenticate every item to be the same as the thing that it was originally seized and it was not altered. The federal rules of evidence govern these important parts. Let's talk about relevance. Evidence is relevant if it has a tendency to make a fact more or less probable than it would without it. The fact has to be of consequence in determining the action. Next, to satisfy the authenticity, you must identify an item and the proponent must produce evidence sufficient to support a finding that the item is what in fact it says it is. And it has to be admissible. There are some things that are just not admissible. Rule 101b6 references that any kind of written material or other medium also includes electronically stored information. And this is very important because, as you see here, there's a whole rule that talks about, or article rather, that talks about contents of writings, recordings, and photographs. So all of these rules of evidence also apply to digital information as well. We really need to concern ourselves with the ability to tell the story. Who is the person behind the keyboard? This is about corroboration and attribution. We have to corroborate online information via traditional investigative methods. This is where police work comes in very handy. So let's wrap up. Here are some tips for effective searches. First, serve the warrant promptly to prevent destruction or tampering of evidence. Verify information using those traditional investigative methods. Make sure you involve technical forensic specialists early and often in the process. And finally, make sure you ask, is this your computer or device? Because if they say yes, then you have a lot more options. So thanks for watching. This has been a quick introduction to the fundamental legal issues surrounding the search and seizure of electronic items. I hope this was helpful and interesting. Feel free to leave any comments on the discussion board. Thanks so much.